Greetings, everyone. Welcome to the DC Bar Pro Bono Center's webinar, Employee Handbooks, a Guide for Employers. I'm Daryl Maxwell. I'm an Assistant Director at the DC Bar Pro Bono Center. Before we get started with the program, I'd like to thank a few people. First, I'd like to thank Lauren Paley, our Program Specialist at the Pro Bono Center, for helping us put all of this together, interfacing with all the folks listening today, and for our implementation of the webinar. I'd also like to thank our friends at Littler, the fantastic labor and employment law firm that had agreed to partner with us. Specifically, I'd like to thank Patricia Donkor, who's on the phone or on right now, and who was keen on this opportunity to present on this topic and develop some really fantastic content for this webinar. I look forward to sharing the insights I've already heard from her with all of you and asking questions and such. Let me also talk a little bit about the logistics for today. Yes, I know a lot of you will have questions about whether or not the webinar is being recorded. It is. Additionally, once you filled out the survey after the webinar is done, if you're listening live, you'll be directed to a copy of the PowerPoint presentation. But for right now, you'll notice in the handout section of your dashboard, there is a link where you can download the presentation. I know lots of you will have questions related to this topic, which is very both timely but also timeless. Those questions you'll be able to ask in the questions box on the dashboard. I will be helping to read through those questions and then sharing them with Patricia as time allows, and making sure that we don't interrupt topics that we know we're going to get through as we go through this presentation. I will just say, as we have been for a number of months now, we're living through particularly unsure times, and there are unsure times for employers like yourselves as well as for the employees that you work with. It's incumbent upon employers to effectively manage staff in order to avoid challenges, potential investigations, and litigation. Having a really strong and forceful employee handbook that recognizes how the operation of your business or your nonprofit works is extremely vital. Both to support your efforts and hopefully not to undermine them if they're, they can certainly undermine them if they're not, if handbooks aren't enforcing the law, but also aren't enforcing the rights and responsibilities of employees and not recognizing the value and the richness of what goes on in your respective offices. Patricia is going to help us walk through some of the highlights and most important points of having an employee handbook, and some of the things that you should be considering when you're either putting one together, or if you have one, if you're looking to revise it or to consider it again. Patricia, I'm going to turn it over to you. And again, thank you so much for agreeing to do this. Like I said before, I will jump in with questions. And if you have any questions, put them in the question section of the dashboard.
Thank you, Daryl. Hello, everyone. I am Patricia Donkor, as Daryl stated, and I am excited to be here. I'm happy to partner with the DC Bar Pro Bono Center. And before beginning, I learned that there were a record number of registrants that signed up for today's presentation, which I'm very happy about, because like Daryl said, this topic is extremely timely, and I hope that everyone on the call walks away with something, whether it is ways to view your current employee handbook, or if you're thinking about making adjustments to your employee handbook in light of COVID-19, or if you don't have one and are thinking about how you should go about getting started. So I'm hoping that everyone takes a little something from today's presentation. As Daryl stated, there will be there's an option for you to submit questions. If you submitted a question prior to today, I would say probably the cutoff may have been about 3 days ago. So if you submitted questions up to that point, I received them and I've tried to incorporate them into today's presentation. And so if you've already submitted those, you do not have to resubmit them. But if you find that I have not responded to that question towards the end of the presentation, please feel free to re-ask that question. But I've tried to incorporate those questions into what I'm going to discuss with you today. As Daryl stated, I am an attorney at Littler Mendelson. Littler Mendelson is a labor and employment law firm, an international labor and employment law firm. We have 80 offices across 20 countries, and we have over 1,500 attorneys worldwide. My particular practice consists of defending companies, both small and large, when they are sued by applicants, current and former employees, or simply providing legal advice on a multitude of issues related to employment law. And throughout the presentation, you will probably hear me say that if you have questions, because this area can be very tricky, especially in today's times where employment laws are constantly changing to evolve with the pandemic and just other hot button issues that have arisen in the employment law context, you will want to run your employee handbook by competent legal counsel. That the DC Bar Pro Bono Center is an excellent resource, and I know that they are there and available to consult with you as you're navigating through your employee handbooks. But I'm also available if you'd like to reach out to me or my law firm, and we can discuss engagement. And here's my contact information on the screen. So I am also a resource if that is the route that you're interested in going. So before we get started, I want to just take a quick moment to give you the lay of the land. This is the game plan. These are the topics that I intend to cover. But as a lawyer, I would be remiss to not mention the disclaimer. I'm hoping to give you all useful information that you can take into your organizations, but this is not intended to be legal advice. Every employment scenario is different, and therefore, again, you will want to contact or consult competent legal counsel before you roll some of your policies out, especially if you're intending to change them and they have not yet been reviewed. So this is not expected to be legal advice. This is supposed to be a high-level presentation that gives you things to think about as you go back to your organizations. So let's talk about why handbooks matter. Handbooks matter because without them, even a small employer can be subject to great exposure. And I just wanted to just quickly talk about the purpose of employee handbooks. So from an employee perspective, employee handbooks essentially set forth the lay of the land. It communicates the employer's expectations of the employees. It allows the employee to know that there are policies that apply across the board. And so it promotes fairness from employee to employee. It's a go-to resource for employees. But employee handbooks protect employers as well. They don't just benefit employees. And we'll talk about this a little bit more, but some policies that you might include in your employee handbook don't just provide guidance to your employees, but they may also save you from liability. So I want to quickly mention the Farger-Elrith defense. So the Farger-Elrith defense, it's named after a plaintiff that sued his employer. In that case, the employee stated that he had been subject to harassment over a period of time by a coworker. The employee had access to the employer's policy manual, the employee handbook. And throughout today's presentation, I might call it a manual, I might call it a handbook, but just so you know, we're talking about the same thing. So the employee had access to the manual, and in that manual, there were clearly defined procedures to follow in the event someone believed they were experiencing harassment in the workplace. The employee sued the employer, and the employer used the defense that we now know as the Farger-Elrich defense and said, look, we have this policy manual. The employee had access to it, and it says what it sets forth what the employee should do in the event they feel they are being subjected to a hostile work environment. This employee did not notify us of that, and therefore there's no way we could have rectified or corrected the situation. The mere fact that the employer had this policy served as a defense to the lawsuit that the employee filed, because it set forth what the employee should have done. Another way that having a robust employee handbook can benefit the employer is there's certain things that you might want to restrict your employees from doing. For instance, we're in the District of Columbia. And just to digress for a second, my focus today will be the District of Columbia. I'm also licensed in Virginia, and I do some practice in Maryland. But because we're here in the District of Columbia and we're partnering with the DC Bar Pro Bono Center, we're going to focus on the District of Columbia. But going back to the previous point, so in the District of Columbia, marijuana use is legal. Recreational marijuana is legal, but you as an employer do not need to permit marijuana use in the workplace. You do not need to accommodate marijuana use in the workplace. And so you can use your employee manual, your employee handbook, to set forth your expectations that your place of work will be free of any marijuana use. And so again, there are creative ways in which you might be able to work around permissible acts within the jurisdiction by setting forth a policy within your employee handbook. Now, none of this that we discussed today is meant to scare you, but I want you to be on notice of things to consider. The idea is we want you to be more informed as an employer providing employment in the District of Columbia. So having an employment handbook, an employee handbook, is extremely important, but you want to make sure that whatever is in your employee handbook is correct, because if you're misstating the law, it can be extremely risky. So I have an example that I'll mention really quickly. So let's imagine a handbook provision that says employees will not be paid for work that is not authorized, and anyone seeking to be paid for unauthorized work will be subject to discipline. And so what do I mean when I talk about unauthorized work? Let's say you have hourly employees, and because they're hourly employees, they are subject to the Fair Labor Standards Act, which states that anyone that works over 40 hours a week is entitled to overtime. And you have told your employees that you have told your employees what to do before taking overtime, and at this point you're fed up, and you have stated you have decided to amend your employee handbook to say if you take overtime or if you work without authorization, you're not going to get paid. That sounds okay, right? Because you've told your employees that they need to have authorization before they work overtime. However, it's illegal. Under the Fair Labor Standards Act, employees are to be paid for any work they perform. So even if you did not authorize overtime, if the employee showed up and performed work during that time, you are expected to pay your employee. And the penalties to employers for violating wage and hour laws in the District of Columbia are extremely huge. They can be up to 3 times what the employee would have made during that time that you decided not to pay the employee. And so, what you would want to do, instead of putting the provision that I just stated, which was you won't be paid, instead, what you would want to do is you would inform the employee via your employee handbook that the employee should obtain pre-approval before working overtime. And that's different than saying unauthorized work will not be compensated. It is setting forth an expectation, a performance expectation for your employee. And that is before you are permitted to work overtime, you need approval. And with that statement in your employee handbook, the way that you would go about someone violating that policy statement is you would performance manage them. So if you've stated that they need approval and they are working without they are working overtime without approval, then you can discipline that employee because it's a policy violation. But you can't not pay the employee. So you want to make sure that when you have policies that they're correct, that they are consistent with the law. So now let's get into some of the specifics. What should companies include in their employee handbooks? What should your employee handbook look like? So because we're in this tri-jurisdiction area, tri-jurisdictional area, we have the District of Columbia, we have Virginia, Maryland. People are going in and out of the jurisdictions all the time. Some of you may have operations in all 3 areas, or maybe 2. So how should you approach your employee handbook in light of the fact that we are in this region that has a lot of crossover? First off, if you're only operating in the District of Columbia, you can have one employee handbook. And so here, as you see on the screen, I'm talking about national handbook and state supplements. And so a national handbook is essentially your general handbook that talks about all of the policies that you've decided to include, to entail the federal policies that are required, to entail, whatever policies that you have for your particular organization. So on those are the general policies that you have in your handbook that would apply to your employees across the board. If you're only operating in the District of Columbia, you can have your national handbook, and then wherever there's a DC specific law, you would highlight that in whatever section. So in the event you have a specific rule for, so for instance, an example might be leave. It might be sick leave. In the District of Columbia, and I'll talk about this a little later, you are required to provide paid sick leave to your employees. So once you, so in your employee handbook, in the leave section, you might have a general statement about leave, and then you will have your specific DC leave policy. So that works if you're only operating in DC. But what about if you're operating in some of the other jurisdictions? What you could do is you could have your national handbook, and then you can have separate mini handbooks for the additional jurisdictions. So your national handbook might be 30 pages, and then your DC supplement might be 5 pages, which will just highlight any specific DC laws that you then provide that supplement and the national handbook, of course, to your DC employees. But then you have your Maryland employees. You provide your Maryland employees the national handbook, of course, and then whatever Maryland supplement that you decide to come up with. And the reason that approach is preferred by many employees, by many employers, is because if your state changes the employment laws, you don't have to then go and revise the entire national handbook. You can just revise that supplement. And additionally, along the same lines, if your jurisdiction changes the law, you don't have to inform your entire workforce workforce if you have people working all over the DMV area or even all over the country. You only need to notify the employees that work in that particular jurisdiction. And then I wanted to quickly just mention the another option that employers like, and especially in today's times where most of what we do is electronic anyway. Employers really enjoy the flexibility that employee policy portals provide. And so essentially those are, if your operations permit, those that basically is just some centralized electronic database or repository that your employees have access to that contains any policies that you may want to provide to your employees, to include an employee handbook. That way, if you're updating and making changes, you might be you're going to be able to send a, usually with the technology today, you'll be able to send an automatic notification informing employees that there have been changes. Employees know exactly where to go to access their employee handbook. You don't have to continue to print your handbooks over and over. And you know they're a lot easier to update when they're online.
Hey, Patricia, can I jump in and ask a question, sort of a two-pronged question, if you don't mind?
Sure.
Okay, so I got one question, and I sort of figured this would happen. So one question was, is the how do you determine the jurisdiction in terms of, is it where your employee, I'm assuming it, you know, or at least the question is it where your employee is located to determine the jurisdiction for what employment laws is in place? And then the sort of follow-up is, what about internationally based employees, particularly in this climate that we're in now?
Okay, yeah, thanks for the question. And I am going to talk about that in more detail a little bit later. But the short answer is it's based on where the employer is located. But there are some caveats that apply, and I'll discuss the caveats when we get there. But the short answer is you, as the employer, you want to be in compliance with the state in which you are operating.
Perfect, thank you.
You're welcome. All right, so we already talked about this a little bit with the last slide. What should your employee, what format should you use for your employee handbook? For this, I'll just add that some employers have, in my line of work, sometimes I'll get a question from employers stating, can I just have a one pager? Can I just have a one-page summary that hits the high points and then, you know, provides links to places where the employee might be able to go to read up on other applicable policies? That could work, provided there is some place for the employees to access the rest of the employee handbook. But an employee handbook that is only one page and there's no, you know, separate or secondary place where the other policies are located is not enough. Between the things that you want to get out just to protect yourself and the mandatory provisions, one page is usually not going to be enough. I don't care how small your operations are. So so what I would advise a client in that scenario is, if you want to have a one pager that you're handing out at orientation when your employees are being acclimated to your business and your operations, that's fine. You can have a one pager, and then during the orientation you can discuss how they're entering their time and, you know, other procedures that would apply during their employment term. But then there should also be somewhere else where they can go and look and access policies that are more in depth. So moving on to the next topic, a question that I get a lot, which is similar to the question that Daryl asked, which is what jurisdiction controls, what jurisdiction governs my employee handbook. Another question that I get a lot is, who should your employee handbook cover? Your employee handbook should cover all of your employees, whether we're talking your part-time employees, your full-time employees, your probationary employees. You have the classification of exempt versus non-exempt employees, and that simply talks about the employees that are eligible for overtime, which would be your non-exempt employees, the employees that are subject to the Fair Labor Standards Act, and your professional employees, which we refer to as exempt employees, and those are the employees that you don't have to pay overtime because usually they're salaried, and they're in the nature of their work is that of a professional or specialized nature. But the point here is your employee handbook is designed to cover all of your employees, and and we'll talk about this more when you're and I'm going to try to give you all some tips on what you should include, and so we'll talk about this in more depth when we get there. But ideally you want to have a policy manual that covers everybody, and when there are distinctions, for instance, if you have a probationary period that you subject your employees to, then you want to state, every employee, if this is the case, is upon hiring for the first 90 days is subject to a probationary period. And at the end of the probationary period, this is what happens when determining whether or not that employee will continue on. But the point is that you highlight when there might be a policy that is strictly applicable to one classification of employee. One of the questions that I got before today's actual session was whether or not your employee handbook should cover contractors. Absolutely not. Your employee handbook should not cover contractors because contractors are not employees. There's a distinction. And this is important because in my line of work, what I see sometimes is you have an employer contractor relationship. So when the relationship first begins, they sign a contract, this is what we expect from you. This is when the contract will end. Your equipment, you'll be responsible for your own equipment, and you will be responsible for hiring your own subcontractors, etc. And so the contract is laid out and the relationship begins. And for some reason or another, the relationship ends. Perhaps it ends abruptly. And the contractor files for unemployment insurance. And you get notification that this former contractor is seeking unemployment insurance. And of course you say, well, he wasn't an employee. So he or she is not entitled to unemployment insurance. What the Department of Employment Services, and that's the department that oversees unemployment compensation in the District of Columbia, what they're going to do is not just look at the fact that you call this individual an independent contractor. They're going to look at the relationship you have with this independent contractor. And so you want to make it clear during the entire duration of that relationship that this is a independent contractor and not an employee. And giving an independent contractor a employee manual may be indicia of more of an employee-employer relationship and not a contractor-employer relationship. And so when there's a discrepancy, usually again it's after the relationship sours, when there's a discrepancy about whether or not the contractor was absolutely a contractor versus an employee, what the courts and the Department of Employee Services looks at is the relationship. It looks at what amount of control you were able to exert over this contractor, and not just the fact that there was a 1099 or that you called the individual a contractor. And so you want to keep those classifications very separate. You can have your own separate policy manual for your contractors. And like I said, the key there is you don't want to exert the same level of control over your contractor that you would an employee, because that's when the waters get a little muddy. You want to keep it clear, but you don't want your employee handbook to cover your contractors. So I want to move on and talk about the contents of an employee handbook. So I have here what is not my actual luggage, but usually my luggage looks just like this. I am a notorious overpacker, and it's inevitable that I throw things in at the last minute, even if I plan my trip in advance. And then when I get to my destination, I usually don't use or wear half of the stuff that I packed. And even worse, there was a trip that I took to Barbados some years ago, and in my luggage, I packed a bottle of red wine. My favorite red wine. I wanted to enjoy it on the beach in Barbados, and I put it in my luggage, and I thought I had secured the bottle, but it broke. It broke in transit, and when I got to my destination, everything was covered in red wine. Um, I bring this up because for you all as employers, I want you to think about your employee handbook like your luggage. And I want you to think about the policies that you include in your employee handbook like the things that you pack. Sometimes you're packing the essentials, but then there's a fine line when you go from packing the essentials to putting in things that you don't need. And then there also is that fine line when you're putting in things that can be harmful. And so you want to think about you want to approach your employee handbook that way. What am I including? Is it absolutely necessary? Does it make more sense for me to have a standalone policy instead of having this in my employee handbook? Or should I just avoid putting it in there altogether? All right, so let's talk about must-haves. What should you ensure your employee handbook contains? Any written policies mandated by law. You absolutely want to have a statement that your company complies with all applicable laws. You just want to have that general statement because you don't want your employee handbook to be an encyclopedia. And so you can't cover everything, but having a general statement that you comply with all applicable laws states that that is your intention, that your intention is to comply with all applicable laws as a default. So that's an important must-have. And then if there are any local requirements that differ from the national requirements. And so I mentioned earlier that I'm going to stick to DC during this presentation, but this is one time that I'm going to deviate a little bit and talk about some of our surrounding jurisdictions. So take Maryland, for example. There are policies, there are requirements that relate to employment that differ from PG County to Montgomery County to Baltimore City, Baltimore County. And so you want to make sure that if you're operating in a jurisdiction that has conflicting policies like that your employee handbook includes all of the necessary policies and specifically and clearly states where they might differ from one another and where they might differ from the national requirements. All right, so this is what I strongly recommend you include in your employee handbook. Who we are. You usually will see that as the first page of your employee handbook, just explaining what your organization is, what you do, welcoming the new employees to your business, and let employees know how to contact you. Let the employees know how to find human resources, or if there are other divisions within your business that you want your employees to have access to, that's a great place to include that contact information. Additionally, you want to include your at-will employment statement. And so one of the questions that we received before today's presentation was, what do I do if I have a problematic employee? So that goes a step beyond employee handbooks, but it's relevant to the at will statement. So if you don't know, in the District of Columbia, all employment is at will. In other words, your employee can quit at any time and you can terminate your employee at any time. There is no mandatory progressive disciplinary procedure that you are required to have in the District of Columbia. And so if your employee is not performing if you're, we're in this pandemic now, if you've seen that since you and your employees have had to work remotely, that you're only hearing from an employee once a week and they're not turning in work, you don't have to keep that employee on your books. You can let that employee go. Now, the caveat, and as a lawyer, I'm going to say this throughout, it's always going to depend, because if you have a contract that says otherwise, that contract is going to govern. But the default in the District of Columbia is that all employment is at will. And so you want to state that up front in your in your employee handbook, that this at will policy is the sole and entire agreement between the employee and my company regarding the nature of our employment relationship. Make it clear that you can leave and I can let you go at any time. And this is also important because a lot of employees, believe it or not, and sometimes employers think that they're required to notice, think that they're required to know that their employer is displeased with their performance. And unless they receive, a written notice or a suspension, that they cannot be terminated. That's not true in the District of Columbia. Again, unless your contract or employee handbook says otherwise. You also want to make sure that your employee handbook is talking about your company's commitment to diversity. In the District of Columbia, there's the DC Human Rights Act. The DC Human Rights Act covers a myriad of classes. In other words, race, gender identity, matriculation. In other words, you are prohibited from discriminating against an employee for being enrolled in school. You are prohibited from discriminating against an employee in the District of Columbia because the employee was a victim of domestic violence, or one of their family members is a victim of domestic violence. And so with this, I just want to say you need to be very familiar with what your jurisdiction protects. And you want to make sure that there is a statement in your employee handbook that states that your operations are anti-discriminatory, you don't tolerate harassment, and you don't retaliate when an employee exercises his or her rights. So that is very important. And as I talked about before, sometimes that can serve as a defense in the instance of a harassment or hostile work environment complaint. If you have that policy, it may protect you if you are sued. You also want to make clear in your employee handbook how an employee complains if they feel they're being discriminated against or subjected to a hostile work environment or harassed at work. Hostile work environment and harassment, they are interchangeable. So if you hear me use those terms, I'm talking about the same thing. But you want to make it clear that the employee knows where to go. And adding to that, sometimes an employee finds that it's their manager that is mistreating them or subjecting them to what they perceive as as discrimination or harassment. And so you also want to make sure that your complaint procedure talks about what an employee should do if they can't talk to their manager. You want to have a section in this human rights portion of your employee handbook that also talks about accommodations. In the District of Columbia, there are lots of accommodations that employees can request. Doesn't mean that they always receive them, but they can at least request them. And so it's incumbent upon you as the employer to, at the bare minimum, tell your employees what to do if they are seeking some sort of accommodation. And so accommodations can be, I have a disability and I'd like you to make modifications to my workspace or make modifications to my hours to accommodate this disability. You should explain to the employee that these accommodation requests should be in writing, who they should be directed to, and then what's expected from you from that point under the law is that you engage the employee in some sort of interactive process so that you all can come up with an accommodation that works for you as the employer, because you're not expected to run your business into the ground to accommodate every sort of nuance that might come up with your employees, but you are expected to engage your employees when they come to you with a accommodation request. So make it clear that you want them to let you know that they're seeking an accommodation as soon as possible, and that and what they should do. There are also religious accommodations that apply. So if an employee thinks that their religion is that one of their work requirements is interfering with their religion, they can request an accommodation. So let them know that you are here and accepting of accommodation requests based on religion and what they should do. And again, you may not always be able to grant them, but you need to at least let the employee know how they can bring those to you. There are pregnancy related accommodations such as lactation. In the District of Columbia, if you have in the District of Columbia, you are required as an employer to make reasonable efforts to provide a sanitary room or location other than a bathroom, where your employee can express breast milk. So where whether they're using a breast pump or however they're doing it, where they can do that and in a sanitary environment. And so you want to let the employee know how to bring those sort of requests to you as well. Continuing on, and Daryl, if there are any questions, feel free to jump in at any point. But continuing on with provisions that I strongly recommend that you include in your employee handbook are the various classifications. So we talked about exempt employees versus non-exempt, and again, those are people that are eligible for overtime or ineligible. You want to tell them who they are so that they know. And this is where you want to also say if you're in a situation where you think you need overtime, what to do to request overtime in advance, but just set forth what the different classifications you recognize, set forth the different classifications that you recognize in your organization within your employee handbook. This is not something that's required, but something that I recommend so that everyone knows who they are and how you as the employer sees them and what sort of benefits they may be eligible to based on their classification. You also want to set forth your core hours. Most employers have core hours of operation. And so you might have a flexible work schedule that you allow your employees to use, but perhaps you have certain hours that you absolutely want your employee to log in if your employees are working remotely, or if they're coming into the office that they should be there. And so if that's the case, you want to set forth that those core hours, that policy within your employee handbook. Another thing that I recommend including in your employee handbook is a statement about leave. And so I've mentioned this before. In the District of Columbia, you are required to provide paid sick leave to your employees. And I'll just quickly tell you what the different categories of employers are and what you're expected to provide. An employer with 100 or more employees shall provide for each employee not less than 1 hour of paid leave for every 37 hours worked, not to exceed 7 days per calendar year. An employer with at least 25 but not more than 99 employees shall provide for each employee not less than 1 hour of paid leave for every 43 hours worked, not to exceed 5 days per calendar year. And lastly, an employer with 24 or fewer employees shall provide not less than 1 hour of paid leave for every 87 hours worked, not to exceed 3 days per calendar year. And so that covers every employer, even if you just have one employee. And that covers every employee, even if we're talking about part-time employees, because it's based on the hours the employee works. And so it's up to you if you decide to provide leave beyond that. So for instance, personal time off, if you decide to provide personal time off, have a section in your employee handbook that talks about how that personal time off is earned. Or if you decide to give your employees personal time off at the outset, have a statement in your employee handbook that discusses that. In the District of Columbia, if you decide to provide leave in addition to the paid sick leave, which again, you're not required to provide any other type of leave, if you decide to do it, you want to include a statement in your employee handbook that talks about what happens at the end of the year with respect to that leave. If you don't indicate in your policy manual or your handbook that the leave is forfeited at the end of the year, in other words, use or lose, that's a concept that a lot of people are familiar with, then under the District of Columbia law, the default is that that leave will carry over from year to year. And so if you provide personal time off and you don't state what happens to the leave as of January 1 the following year, then that leave carries over. And so make sure that if you decide to go that route, that you are clear about what you want to happen with your leave. Have a section for holidays. Actually, I'm saying have, but these are recommended. It's not required, but I think it helps in ensuring that everyone is on the same page. If there are certain federal holidays that you're going to observe, then have a section so that employees know that. In the District of Columbia, employers that have 11 employees or more must pay the first 5 days of jury duty. And so that's something that you need to know is on the books, something that you as an employer are required to do if you have more than 11 employees. But in the event that you have less than 11 employees, if you decide to have a provision in your employee handbook about jury duty, perhaps that's where you state, sometimes you might be summoned to jury duty, and if you're summoned to jury duty, here is what you're expected to do. They can use their own leave, they can take unpaid leave, whatever, but you might want to explain what your expectations are with respect to jury duty. Another provision that you want to include, or that I recommend you include, is the pay schedule. When employees will be paid. What happens if the payday falls on a federal holiday or something to that effect? And there actually are DC laws that speak to that. But that's something that you may want to consider including in your employee handbook, particularly if certain employees are on a different pay schedule. You want to include a provision that talks about what employees should do if they're injured on the job. You want to include, or you want to consider including what you would expect from your employees, what your employees should expect from you when it comes to their personnel files. Are you going to, how are your employees to access their personnel files? In the District of Columbia, there's no particular law that sets forth what is supposed to happen, but there are other jurisdictions where it's very clear that this is how the employee is permitted to access their their employee personnel file and where they can access it. And so you want to make sure that you're in compliance with whatever jurisdictional laws apply in that context. And so I'm going to try to go a little bit faster because it looks like we're getting low on time. There's so much information, but here I've listed optional policies, and these are things that if they apply to your business operations, include them. If they don't, then don't worry about it. But one of the bullets that I do want to highlight is personal appearance. In the District of Columbia, like I stated, there are a lot of classes that are protected. And again, when I say state class, I'm talking about demographics. I'm talking about characteristics. And one of those classes is personal appearance. In the District of Columbia, an employee can sue for discrimination based on their personal appearance. And so if you're going to have a personal appearance policy, you should consider limiting that policy to uniform and not get too boggled down in uniform. You want them to have a neat appearance, or very general things like that, but not get too boggled down, especially avoiding policies that talk about hairstyles and things of that nature. If you decide to have a policy that talks about performance reviews, what I will say on that issue is, if you're not going to follow it, don't include it in your employee handbook. Some employees are going to be evaluated every year. Some employees may not be evaluated every year. If you're inconsistent, or if you know yourself and you know all that your business operations are responsible for, and you may or may not stick to that schedule, don't include it. Instead, you should include a provision similar to what I have here, and that is basically, you know, they may or may not be scheduled, and it's in your discretion as the employer to determine that schedule. All right, so here's where I'm going to address the question about which law applies. And so we're in this COVID-19. We're what, 9 months in to this pandemic, and so it's been going on longer than anybody would have ever imagined. And so a lot of folks are working from home. I have been working from home since March, so I'm talking to you from my basement right now. Um, and so just some quick points on this. I get questions all the time. I am now having to transition to telework for my employees. Should I include my telework policy in my employee handbook? My recommendation is no, um, but I have to add a caveat to that. So you may have had some employees that were already working remotely. You may have had some employees that were working remotely pre-COVID, and or perhaps you had a permissible work from home policy, and you know, as long as the employee notified you a day in advance, they could work from home, and perhaps you still want to keep that policy within your handbook. That's fine. um you know, that's fine. But if you decide to have a policy that addresses the new remote work environment, I recommend that you make it an agreement. And I say that because there's a lot of gray area when we're talking about telework. So for instance, um depending on where your employee is working. So perhaps you have an employee that, you know, we're in the District of Columbia. There are a lot of transplants in our area. Perhaps you have an employee whose home state is California. And during the pandemic, because they're not going into the office, they've decided to go home and work at their parents' home or at a vacation home. Typically, your state in which you work would govern the laws that apply to that employee, but sometimes it might depend. So for instance, if you have a confidentiality agreement, if you have a restricted covenant, which basically states what an employee can do after the employment relationship ends. You see these a lot in the sales force, where the employee cannot compete against the employer after the relationship ends. Those agreements are often covered by state law. And so you might have an agreement here in the District of Columbia, but once that employee resigns and is in California, perhaps the California law might apply. And so that's another place where you might want to consult with outside, excuse me, you might want to consult with counsel, not outside counsel, but counsel in general. Or one thing that I recommend that you do is even before you get to the consultation with your attorney and trying to figure out how you can address certain situations and where employees are working, you in your telework policy may want to consider having a default provision that states employees that telework should work in the same state where their office is located. Perhaps you have a provision that states that and requires that any employee that chooses to work elsewhere must get approval before they relocate to California or wherever it is they are choosing to to work remotely. And that way you at least get an opportunity to assess the laws in that other jurisdiction to see if they might apply and to see if there are other responsibilities that you may have to that employee while they're in their home jurisdiction. Um, Daryl, I have more, but I know that we're running low on time. Do you have any questions, or do you want me to just quickly
I
finish the PowerPoint?
Sure. So I do have a couple questions, but I would like, why don't you, and hopefully we'll be able to go maybe a little bit over 1 o'clock to get through some of these questions, but there aren't that many questions. So why don't you get through a little bit more of the content and don't
Okay.
don't feel the need to rush through it too much. but there are a couple questions here for you.
Okay, absolutely, and I don't mind going past one. I think this is an important topic, and whoever can stay past one, you're welcome to join me as I go through the rest of this presentation. Another piece of advice that I would give regarding your telework policy is look for inconsistencies. So don't roll out a telework policy that may or may not, that may conflict with your existing policy. So double check to make sure that something that you're stating in your telework agreement does not conflict with something that you already have in your employee manual. You also want to consider what you're going to do about reimbursements and equipment. So in the District of Columbia, employers are required to pay or reimburse employees for uniforms, protective clothing, tools, and equipment. And so now we enter this gray area. What is equipment? What is equipment in this new COVID-19 alternative universe that we're all living in? The short answer is it's not clear. And so there may be equipment that you are expected to provide your employee. And you really won't know how a court will come out on this issue until your employee sues you for reimbursement of that equipment. And so what I will say here is if you are absolutely requiring your employee to work remotely, then you want to consider providing the bare minimum equipment, such as like a laptop, or if they're required to be on webcam a lot, perhaps ensuring that the camera that they're using is efficient, and allowing them to get through a particular WebEx or Zoom meeting. You also want to consider having a provision in your telework policy that states in the event an employee finds that they need additional equipment to perform their work at home, they need to seek approval from you first. And that way you are able to assess whether or not it's something that you're going to pay for or whether or not it's even something that's needed. Another gray area is now that employees are working from home, is what sort of OSHA requirements or guidelines might apply. And OSHA is essentially occupational safety, work hazards. And so with your telework policy or agreement, and I'll explain why I keep saying agreement in just a moment, one thing that you may want to consider doing, because again, this is a gray area, is you want to consider having some sort of checklist in your telework agreement that states, employee agrees that their work environment is safe. Employee agrees that their work environment is ergonomically sound. Employee agrees, that their work environment is free of distractions. That way, you're at least having your employee thinking about it at the outset, and you're not being surprised later on when the employee states, I've been sitting at this chair for, the last 9 months, and now I have back issues. And I think it's your responsibility to cover these issues because you, employer, required me to work from home. Now, I will draw a distinction between employees that are required to work from home and employees that choose to work from home. So perhaps your place of business is now back open, and you have some employees that are stating that they would rather be home. When you're mandating an employee to work from home, I think that the courts will decide that your responsibilities to that employee are more pronounced and higher than if your employee is choosing on their own to work from home. Now, quickly, I want to just talk about some policies that you want to avoid. I mentioned this briefly when we were talking about your the performance review schedule, assuming you are going to review your employees on an annual, semi-annual basis. If you aren't sure if you're going to do it, don't include it. So avoid having aspirational policies that you yourself might violate. Also, if you have a number of different operational facilities, so let's say you have an industrial facility in some place, and then you have a corporate office in another place, and then you have a client-facing location. If you have lots of different facilities and your expectations and policies vary from facility to facility. Perhaps you don't want to have you don't want to include those operational policies in your employee handbook, but instead may want to have some general provision that states, all employees are expected to, clock in at the beginning of their schedule, and they're expected to do this, and they're when they're concluding their schedule, and if they have any issues, they're expected to report. But then during orientation, you can tell employees about the nuances that are specific to their facility in which they're working out of. And then maybe, again, if you're able, have an online portal where the employee can access more specific information, or have a point of contact if employees have questions. Again, you want to avoid having any contracts that go beyond your requirements as an at will employer within your employee handbook. And let me tell you what I mean by that. So I have a client, I have an employer who has had to lay off the vast majority of their workforce since COVID hit. And the few people that they have kept employed, they have required those employees to take on additional tasks. What they've done to compensate those employees for the additional tasks that they weren't previously doing is they've entered into a separate agreement with the employees to compensate them for the additional work. And so you have their employee handbook that states their general expectations as employees, but then you have somewhat of a 1099 relationship for the additional task. You wouldn't want to incorporate that additional agreement into your employee handbook. You would just want to have that standalone contract govern whatever additional agreements are made or side agreements are made. All right, so just a quick point on unlawful policies. Again, this is why it's important to seek legal consultation to ensure that you do not have impermissible policies within your employee handbook. I've seen, believe it or not, employers have policies that state, if you go an entire year without an injury, you are subject to a bonus. Or if you have a perfect attendance policy, you're subject to a bonus. Perhaps the employee has an accommodation that requires them to take off work here and there. And so they need intermittent family medical leave. And so having a policy like that could venture into the unlawful policy territory, because it's encouraging employees to not exercise a right that they otherwise might have. Same thing with, if you're not injured, you'll get a bonus. I mean, OSHA has workplace policies and expectations. And so if you're telling employees that they will be rewarded if they are not hurt, you're encouraging employees to not report injuries, which can run afoul of OSHA requirements. I quickly want to just talk about some of the areas of vulnerability that I see. So for you all that are aware, you have the Federal Family Medical Leave Act that applies to employers that have 50 employees or more. And then there are other provisions that state which employees should be covered. You want to make sure that you're familiar with the Family Medical Leave Act specifically. You may want to have a word or two within your employee handbook that states, if the employee is interested in taking FML leave, contact this person for eligibility and to request it. And then that HR employee can then, sort through that individual circumstance. But you want to at least acknowledge the fact that certain employees are entitled to this federal leave. And in addition, you also want to have the required notice posted somewhere in your place of business, posted in a conspicuous location in your place of business, which could potentially include an online portal, provided every employee has access to it. And so I've just included here where you can find the FMLA poster that the Department of Labor has provided. Now, again, we're talking DC. DC has its own Family Medical Leave Act, and it differs from the federal Family Medical Leave Act. It differs in that more employers are covered. And so with the federal, you had to have 50 employees. With DC, you only have to have 20 employees to be covered under DC Family Medical Leave Act. It also allows more employees to be covered. The employees do not have to work with you as long as they are required under the Family Medical Leave Act that the federal government provides. And so you want to be familiar with that. And again, you may consider addressing it within your employee handbook, even if it's just to the extent to state that, it's something that the company complies with as one of the applicable laws. And if you seek to take leave under the DC Family Medical Leave Act, this is what you should do. The Department of Employee Services, the DC Department of Employee Services, and if you're not familiar with this agency, you need to go onto their website, peruse their website. There are all sorts of notices that are pre-prepared that you can simply print out and post in your place of employment to ensure that you're in compliance with DC law. Some of these notices are required to be posted. And so here I've just included the website for the DC Family Medical Leave Act and the sample notice that the Department of Employee Services post on its website, which you can print and then post in your place of business. All right. So this is another area of vulnerability, and it has to do with meal and rest breaks. I will quickly just say, DC does not have specific provisions that governs what is a rest break versus a meal break. And the distinction is rest breaks typically are compensated. So those are typically your short breaks, usually 20 minutes or less. And the meal breaks can be uncompensated. The federal government does not have a defined rule either. But when it comes to wage and hour disputes, typically where courts draw the line are short breaks should be compensated. So, your 5-minute bathroom break, anything under 20 minutes usually is seen as a short break unless the local jurisdiction says otherwise. And anything at 30 minutes or longer, or actually I would say 20 minutes or longer, is considered a meal break and not compensated. So you want to be aware of those policies, in whether or not you include them in your employee handbook. You want to be aware of them, and it's up to you, optional, about whether or not you want to include that information in your employee handbook. What I will say is, when you're dealing with employees that are non-exempt, in other words, your hourly employees that are entitled to overtime, if you have employees that fall into that category, it is advisable, whether you're putting this in your employee handbook, whether you're, informing them at orientation and then reminding them through an online portal, that they are not to work during their uncompensated meal period. Because if they work, that time can be considered towards overtime. So you want to make sure that that's something that you're considering when you're communicating your expectations. With respect to standards of conduct. So you can include standards of conduct in your employee handbook. In fact, it's advisable, but what you want to do is you want to stick to things that are criminal in nature. So you want to, or things that are inarguably prohibited in the place of work. So things like fraud, use of drugs, falsification of records, violence, use of employee equipment for personal reasons, working overtime without approval. Those are the sort of policies that I would recommend you include in a standard of conduct if you choose to have one. What you want to avoid are policies that have to do with personnel information. So you should not have a policy that says you as an employee cannot discuss your wages with anybody. That's illegal. Employees are permitted to discuss their wages with their coworkers, with fellow employees. So the takeaway there is you can have a standard of conduct, but stick to things that are clearly impermissible in a workplace, and try to avoid things that could become controversial or could be seen as infringing on rights that employees are otherwise permitted to exercise. When it comes to attendance policies, you certainly can have an attendance policy and state your expectation, but you want to have some sort of carve out that says, well, one, you want your attendance policies to just be neutral, and you want to have some sort of carve out that states that, notwithstanding the applicable law. And so that employees know that they may still take leave for some of the permitted leave reasons in the District of Columbia. For instance, one of the quirky permissible leave categories in the District of Columbia is parents, legal guardians, aunts, uncles, spouses, domestic partners. They are entitled to 24 hours of leave in a 12-month period to attend or participate in school-related events for their children. This is unpaid leave, but they're entitled to do it. And so if you have a attendance policy that says you're not permitted to take off unless you're absolutely ill or in the hospital, that's not a neutral attendance policy, and that would then infringe on some of the other leave categories that employees are permitted to take, even if those leave categories are unpaid leave. So I'm coming to the end, but I have just a couple more things that I want to mention before we wrap up. So this is the slide on confidential policies, and we received a question about confidential policies before today's webinar. And what I will say about that is similar to what I will say about the standards of conduct. You're permitted to have confidential policies. You're permitted to protect your information, but focus on your information as the employer and not information that is specific to the employee. In other words, don't have a policy that says the employees are not permitted to discuss their benefits or their salaries or their if they're feeling like they're being discriminated against. Don't have a policy that prohibits the employees to freely exercise those conversations. Your policies related to confidentiality should focus on you as the employer. So if you want to have a general policy that states employer confidences and trade secrets are strictly confidential and should remain that way, again, you want it to be employer focused. Some employers actually will list things out, such as customer lists, company financial information, marketing strategies, or again, you can have something more general that states employer information or employer protected information not related to personnel data should be maintained in a confidential way. All right, and then with respect to the last slide, I just wanted to remind you all that if you're operating in DC, you need to be very familiar with the Department of Employee Services. It is a resource. Today, tomorrow, by the end of this week, if you haven't already done so, go to their website and see what notices they have to offer that you can print. And again, some of those notices you should have already had up if you are already in business. And so you may want to print them now. But certainly visit that website just to make sure that you are in compliance with all of the laws stated there by the Department of Employee Services. So that's it for me, Daryl. I rushed through the end, and I know I talked about some of that stuff pretty quickly, but that is the presentation. So if you want me to answer any of the questions, I am happy to do so.
Sure. And thank you so much, Patricia. So one of the questions I was holding was, can you talk about all the specific notices that employers have to give employees? And I think it's perfect that the DC notices is up on the screen because there were a couple of folks who were asking, either about notices and also just about, is there a place to find all of the laws, particularly relates to DC, that we should be in compliance with? One of the listeners was saying she felt they were hidden. So I wanted to give you a little bit of time to talk about that.
So yes, the employee, so as a starting point, Department of Employee Services website. But many of the other laws are they're not hidden, um, but they're not they're not hidden in the sense that they're accessible. They're accessible online. A lot of these laws that I spoke about are DC statutes that you can find on the internet. And so sometimes just conducting a general search of employment statutes in the District of Columbia might get you somewhere. The Department of Employee Services, I am pretty positive, has a link to the applicable employment law statutes that apply in the District of Columbia. So you want to visit does.dc.gov. You want to do a Google search about employee and employment policies generally, and then you also want to run some of your questions by competent counsel, because everything may not apply to your individual circumstance. And so I don't want you all to flounder out there on your own. And sometimes, again, if pay is an issue, we have great resources like the DC Pro Bono, the DC Bar Pro Bono Center, excuse me. But yes, so they're accessible, but not always apparent, but they are out there.
And you're right, and thanks for answering that. And so we, as the Pro Bono Center, we provide free legal assistance both to businesses and nonprofits who are looking, and we're looking for this kind of information. And so as you have additional questions, as we get to the end, I'll make sure to put either in the chat or let you know that we have resources available. We have a weekly small business clinic where you can ask these kinds of questions. And also, I will also mention, because a couple people had been asking or trying to figure out, hey, is this going to be recorded? I put it in the chat that yes, this is being recorded, so you'll be able to listen to or share this with friends and colleagues after the fact. And if you look in the dashboard, there is a copy of the presentation that you can download as we speak. One of the things I also wanted to make sure to get to, let's see. One really specific question about whistleblower policies. I know we work with a lot of nonprofits who typically have a separate whistleblower policy, from their employee handbook, but is for the sake of best practice. Does it matter if there's a whistleblower provision in your employee handbook, or if you need to have a separate whistleblower policy?
No, it's not. Either are fine. I would at least at the bare minimum address the whistleblower protections in your employee handbook. And if you want to go into greater detail, you can have a standalone policy. And the way that you can address the whistleblower policy is to state that you are an anti-retaliation employer. I mean, that's essentially what whistleblowing comes down to, an employer retaliating against an employee for reporting things that they are permitted to report under the law. And so at the bare minimum, you want to have that. You may also want to reference the DC Human Rights Act and the fact that you're in compliance with the DC Human Rights Act and all applicable laws, which would include the Whistleblower Protection Act, that is covered under the DC Human Rights Act, and then also covered under the federal law. So it's up to you, but if you want to have a more in-depth standalone policy, but your employee handbook at the bare minimum should say that you are an anti-retaliation employer.
Sure. And then I've got one last. I think we've touched on just about everything that folks have been asking. We've got one last question on DC's family paid leave. I think this particular participant was looking just for any guidance you can think of on. They're an organization that happens to have seasonal employees, so they're just trying to figure out how best to navigate the new paid family leave law. And I will quickly note that we, the Pro Bono Center has done some training on paid family leave and have a webinar on the topic. So I may actually put that while you're answering this, I may put that information in the chat as well. But if you had any tips, that would be really helpful.
I would say, in the interest of time, that it's extremely expansive. It applies to adoptions, it applies to family members, and I would become familiar with it. You can, I would become familiar with it, and so I would recommend that you look at the resources that the Pro Bono Center is including in the chat, and make sure that you print out the notice and include that.
Okay, well, I will just say it has been such a pleasure having this conversation. I know we went over a little bit, but thank you all for being flexible, and Patricia, it's been such a joy to get all of your knowledge and expertise and to share that with our participants. So thank you. I would just say, and a couple people had asked this earlier, folks were thinking, oh, do you have, are there options, or is there employee handbook sort of drafts we can look at, and we didn't want to share any written materials. However, what we will do, and as we close out, again, I want to say thank you to Patricia and thank you to Little Mendelson for being such a great partner on this webinar. As we move forward, we will send out a survey to all the participants after the fact. And one of the things we're going to ask is if you need additional assistance with either creating or drafting an employee handbook, or having somebody help you to revise the handbook. And we will try to assess both the need and whether or not it's a resource we can provide. We believe we'll be able to do that, but we want to sort of get a sense for folks participating who's going to need that sort of help. So you will get a survey from the Pro Bono Center probably later today or tomorrow, requesting sort of your thoughts on how fantastic the webinar was, and we will also be asking a question about moving forward. Again, this webinar was recorded. It will probably between now and the end of the week will be up on our resource site, www.lawhelp.org/DC/CED, where you'll be able to share that information with your friends and colleagues. And if you need to listen to any portions of it, again, you'll be able to. Again, thank you for participating. Have a wonderful day.